Okay, go ahead.
Good morning, everyone, and welcome to Law Talk. Today we're going to talk about the Supreme Court's recent decisions. We haven't done a Supreme Court decision show in a while, and the Supreme Court's been busy. Some of the things they've been busy doing have been turning down cases, and that's in today's environment just as important as some of the things that they've heard and decided. So, one of the cases that they turned down recently was an effort to limit police liability for what they do on the job. They refuse to hear that. So, in other words, they are not wading into the controversy about police being able to limit liability for what they do on the job. And this left intact the ability for people to sue police officers for what they do on the job. Another thing that they decided not to hear were 10 cases that involved expanding gun rights or challenging restrictions on gun rights. For example, New Jersey, in order to carry a firearm outside of your home, you have to show that you have a good reason to do that, that you have an actual, it's a very high barrier, that you have an actual need based on threats or having been attacked or robbed. I mean, something bad has to happen to you or potentially be imminently happening to you when you apply for a New Jersey license to carry. And so that was brought to the Supreme Court saying, look, this has nothing to do with the right to keep and bear arms not being infringed. They've turned it on its head. Instead of saying that they have to show why you don't need a gun, you have to show why you do. And that's really not how rights are supposed to work. If you have a right, it's supposed to be presumed that you can do that thing, and then the government has to show why you can't. And this New Jersey law flipped that on its head and says, no, 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 you have to show why you need a gun, why you deserve a right to exercise your right. But the Supreme Court refused to hear it. Now, we're not sure if they turned down these 10 cases because the Supreme Court thought that these laws were constitutional, or sometimes they turn them down because they think that there's a flaw in the way that it's presented. But nonetheless, if you want to carry a gun in New Jersey, you currently have to go through the hoops that they want to put you through in explaining why it is that you need a gun. So you have to have been attacked or threatened or something else in order to obtain that license to carry in New Jersey, according to what the Supreme Court explained. So, one of the biggest decisions, though, that came out in a different sense, those were things that the Supreme Court decided not to hear. What the Supreme Court did hear last year and decided on was a landmark, what's being described as a landmark civil rights case. And this law protects gay, lesbian, and transgender people from discrimination in employment, which is something that people in that community have been seeking for a very long time. The majority of states in the United States did not protect sexual orientation the way the New York State does as a category for which you were protected from being fired. So, in other words, in most of the states in the United States, if you came out or acknowledged that you were a homosexual, even though you would now have the right to marry in the state due to another Supreme Court decision, you could still be discriminated against in employment. So, an example that was given in one of the commentaries on this was that if a company hires a man for whatever reason, and he is going to work all these, for whatever period of time, and then he shows up in dress or otherwise in feminine, stereotypically feminine attire, and starts calling himself and insisting everyone else call him by a stereotypically feminine name, and stating that he believes that he is a woman, and you used to be able in the majority of the states to fire him for that or fire her for that. Now you can't. Now, as long as that person continues to do the job that they are hired to do, then they can't be fired. Now, this has caused a lot of controversy in some circles because there are some places and ways that it is believed that a female worker is best. So in some of these places, it would be, for example, in a rape crisis center or a women's shelter. It is believed that it is believed by many people that someone who has been in a crisis situation, they don't want any men around in that situation. And so even someone who was biologically seen to be male at birth and then identified as a woman, they are thinking that this would be harmful. Now, there's another school of thought that in these situations that there should be men there who identify as men and appear as men, just to kind of reassure the woman that all men aren't bad, so that it's good to have men in this situation. So there's that controversy. But how a man or someone who formerly identified a man or was identified as a man and then comes to work and identifies as a woman, is it in those situations where gender seems central to the necessity, a bona fide occupational qualification, like the Supreme Court calls it, then you could or could not discriminate. We don't know. Now, what is a bona fide occupational qualification? Well, in some things, for example, if you want to be an air traffic controller, probably if you have the disability of being blind, you may not be able to do the job of an air traffic controller because you can't see the planes from the tower, nor can you see the radar or whatever they're using now that they would need to identify to keep airplanes safe. And when they made this law, they said, well, you can't discriminate against people with certain disabilities unless it's a bona fide occupational qualification. And in some cases, gender has been considered a bona fide occupational qualification, and therefore you could say that you needed a man or a woman for the job. But now it seems that if you hire someone who is the gender that you were looking for, that's believed to be a bona fide occupational qualification, as I said, like in a rape crisis center, domestic violence shelter, women's locker rooms, and then you identify differently, that would impact your ability and your permissions to do the job. So one of the controversies surrounding this is that the law says that people shall not be, it's called Title VII, it's a federal law. It was passed in the Civil Rights Act of 1964. And it says that it bars job discrimination because of sex, among other reasons. I mean, it gives a whole list of reasons, but sex is one of them. And they didn't say gender. And I've noticed that for a long time. It seems to be that what they meant was gender. And the Supreme Court doesn't deny that what they meant was gender. The Supreme Court simply says that you can't discriminate on the basis of sex, and that sex means what it says, and that what they were talking about at the time was gender. But now we understand that there are a lot of genders, or more than two genders, and so that Title VII, even as originally written, although they're not really arguing the originalist theory, but even as originally written, since it does refer to gender, and we now understand that there are lots of genders, and our culture has evolved to understand this, that we now have Title VII covering different gender orientations, transgender and such, and so that therefore you cannot discriminate on the basis of that identification, and you can't fire people for that. How are we doing on time, Frank?
We're doing just fine. We got 1 minute.
Okay. I'm working remotely, so I can't see the way I used to. So what does this mean now? Well, there are all kinds of implications that now can be had because of this. So we're starting to think about Title VII protects girls' sports, for example. So when my girls were growing up, I'm a mother of 5 girls, I got 2 of them on the quote-unquote boys basketball team in their school because the girls basketball team didn't play anyone else, whereas the boys basketball team went and played other schools. And that was against Title VII. You can't restrict one gender to a totally unequal ball team. And the school, to its credit, agreed and put the girls on the boys team. And so they were able to play that. But now we're wondering, are people who are biologically identified as male, they grow up, they want to join the girls' team, how is that going to go? So I think it's about time for a break.
Yep, we'll be right back with Law Talk here on The Patriot. Yeah, it was a little over a minute when you asked, but I thought saying a minute would be easier, so that's why I hadn't started playing the music yet.
Oh, okay. Yeah, I forgot about the music thing. We'll just do that.
Can you, I'm afraid that you won't be able to hear it without me turning it up too loud, so I hope that's not an issue.
I hope not too, but we'll just see what happens.
We'll give it a shot on the next break. It can't hurt.
Right.
So.
Give it a try.
About a minute here.
Okay.
rejoin's just about to start. Okay, go ahead.
And we're back with Law Talk, and we've been talking about the Supreme Court of the United States and things that it declined to hear and things that it is hearing. So if you're just joining us, two of the things that it declined to hear are cases involving police officer liability for acts they do on the job. The Supreme Court left intact the ability to sue police officers for things they do on the job. And then 10 gun rights cases. And we talked earlier about the very extreme New Jersey hoops you have to jump through to get a license to carry a gun in New Jersey. And then we moved on to transgender rights, gay, lesbian, bisexual, and transgender rights that the Supreme Court has now recognized coming under Title VII of the Civil Rights Act of 1964. And so it is now the law of the land that in employment anyway, you cannot discriminate against people in the lesbian, gay, bisexual, or transgender community as long as they're doing the job they were hired to do. If they come into work the next day identifying differently than they did before, or you discover that they've always identified a certain way, you can't fire them. That's their livelihood, it's their job. Now, some people are concerned though, because Title VII covers a lot of other things. So it was brought to the Supreme Court as an employment discrimination case. But since it was determined by the Supreme Court, it so to speak, bought the argument that Title VII protects the lesbian, gay, bisexual, and transgender community from discrimination in employment. This law also covers a whole lot of other things like sports and, which bathroom we can use and that sort of thing. Now, the bathroom controversy that came up under the presidency of President Obama, a lot of people solved that simply by having neutral gender restrooms. And instead of having a big restroom with a lot of stalls, they just had more than one restroom that just said restroom on it. So this may require, in order to sort of keep everybody happy, rather than having gender identified restrooms, which are big rooms where people congregate and take care of biological needs, we may just need to have a bunch of closets in the wall, so to speak, that are bathrooms, which each one just says restroom on it. So this may require a redesign, so to speak, of restrooms in America. And in some ways, that's not a bad thing, because in other countries, the restroom is essentially a room where you go in and the door shuts. In America, we go into a restroom and there's this sort of, usually a metal door that sort of blocks where the most important things can be seen, but it doesn't go all the way to the floor or the ceiling. So we may wind up with more European-style restrooms in the future. So that's not such a big deal. That's going to cost money to change if it is changed, but it's not going to impact our culture, society in a major way. The Europeans have been doing it that way for a very long time. What will be more impactful will be things like, do we allow, and right now the answer is yes, do we allow people who identify as a gender other than what their biology historically had implied, do we now allow anyone who says they're a woman or anyone who says they're a man because they have this deeply held belief that that's what they are, do we now start letting them use the locker room, for example, where people are getting changed together? And again, this can be modified or ameliorated in some way, these concerns, by simply having locker rooms not be large rooms where everyone runs around naked, but by having, so to speak, private sort of closets where people change, and then nobody's running around seeing anyone else naked, having the showers in sporting facilities more private, so that, again, you're not seeing each other's bodies. So it seems that a redesign of these facilities would alleviate a lot of the concerns. What is going on here is that our culture is evolving to understand or believe we understand more things about human psychology and not wanting to harm people because of things that they cannot change. And whether or not they should change it or not, that's a whole nother debate. But the idea is that the science has come to understand that people cannot change their gender identity, whatever it is, and that when we go ahead and we make rules that impact the ability of people because of their gender identity to make a living or participate in sports or anything else, it can be difficult to reconcile that with the idea of equality for all. Now, the other area where it's difficult is in sports, because men, I understand, have been taught since I was a child, have a different center of gravity than women do. That women have a center of gravity in our hips, and men have a center of gravity in their shoulders, and that impacts the ability to do certain things, like, for example, push-ups. That women often find push-ups easier to do on the knees rather than the toes because of the fact that the center of gravity in the hips interferes with the ability to do push-ups in that way. And that for men to get the equivalent experience would have to have a very heavy weight on their hips while they're trying to do push-ups in order to understand, the different center of gravity thing that women have when we're trying to do push-ups. So the argument is that this sort of thing, the different muscle mass percentage in people who are born what we have traditionally identified as biologically male, would make it unfair for people who were previously identified as male and had the hormones growing up as male and that sort of thing, to then decide when their bodies are fully developed as male bodies to decide, okay, that they're female, because then that might give them an unfair advantage in women's sports. So that's a very important issue that's being raised about this concern, because Title VII has been used to promote equality in sports, and now they're saying you can't discriminate in any way against transgender individuals. So if someone believes or finds out, or however you want to put it, that they're not male, that they're female, and then they want to compete in women's sports, there's a concern they'll have an unfair advantage. So one of the ways of getting around this is simply to eliminate gender in sports. You don't have a boys team and a girls team, you have a team. And then if, the girls want to play football and the boys want to play softball or whatever it is, fine. And then people get to play either based on merit, as in some schools, or they take turns, as in other schools, so everyone gets to play. So there are different ways of handling this. But eliminating the concept of gender as a qualification for a sports team may be the way we're going to have to go, because you just aren't going to be able to resolve. I don't know how you could resolve the issue of people who were developed with more muscle mass because of the hormones that were generated by their own bodies, then competing with people who had a different, predominantly different biology that didn't give them the same muscle mass. That's what I've been taught anyway. I mean, I've been taught that people who were born male wind up with a whole lot more muscle percentage to their body weight than females do. And if that's not true, then that's a different story. But my understanding is that's a true story, and that's the way things have been. And so it brings about the concern that there might be some unfairness in sports. So there's the sports, there's the locker room, there's the bathroom. So again, the locker room and the bathroom things seem to be fairly easily, with just some modifications, which there'll be a cost for. It'll be expensive, but we'll have to take care of that. So it's getting to be time for a break, and we're gonna be back in a few minutes.
So you can hear that okay?
I heard it sounded more like static than anything else, but I heard that you were doing something. So.
Okay. It's probably not the best bed, like music bed for it, but it's the only thing I can find in the system.
Okay.
That didn't have something already over it. So I'll try to look for something a little bit better. That's more like, for lack of a better word, like patriotic, a lot of like big drums and stuff. And I don't think that would come through as good on your end. So I'll look for something else, but at least you can hear it.
Yeah, I can hear you're doing something, so I took the hint. My grandson is playing music in his room. Can you hear that?
No, I couldn't. No.
Good, good.
All right, just about 1 minute.
Okay.
All right, your rejoin's just about to start. Okay, go ahead.
And we're back with Law Talk, and we're talking about the Supreme Court's decision to recognize gay, lesbian, bisexual, and transgender equality in employment. So how did we get here? We talked about some of the ways that theoretical ways that this could impact society, but let's talk about how we got here. There was a man who worked in a funeral home, and the man confided in his boss, Thomas Rost, that he had worked on gender identity issues and had been beset by gender identity issues his whole life. And so he decided that he was going to be true to who he believed he is. And he decided that after vacation, he was going to come back to work as a woman named Amy, which is how he felt the true him was. And he assured his boss that he would wear a conservative women's skirt suit and that he would look to all the world like a woman, and that shouldn't impact the business. And his boss's response was to fire him. And again, this was a good employee. This wasn't someone who was on the verge of getting fired anyway. Ross simply fired him because he intended to come to work dressed as a woman. So that was one of the cases. There were other cases. Another one was a skydiving instructor who was fired because of his sexual orientation. And you would say, well, why would that matter? And the Supreme Court decided it doesn't. The full Second U.S. Circuit Court of Appeals ruled 10-3 that it was abandoning its earlier holding that Title VII didn't cover sexual orientation because legal doctrine evolves. So basically said, we're evolving. It's, may not be what the original people meant, but we've decided that legal doctrine evolves. And the court held that sexual orientation discrimination is motivated, at least in part, by sex, and this is a subset of sex discrimination. So the ruling was a victory for the gentleman named Donald Zarda, who was fired in 2010 from his skydiving job in Central Islip, New York, that required him to strap himself tightly to clients so they could jump in tandem from an airplane. So for those of you who have never jumped out of a perfectly good airplane on purpose, and I haven't, my understanding is that the first time you go, they strap you to an instructor. So if you panic, the instructor can do what needs to be done, and then you don't die because you panicked and forgot what you were supposed to do. So Donald Zarda had to be strapped to this person. So he was trying to put a woman with whom he was jumping at ease by explaining, listen, we're going to be strapped tightly together. But he said, don't worry, I'm gay. It's not going to make me feel a certain way on the way down. And the school fired Zarda after the woman's boyfriend called to complain. Now, why the woman's boyfriend called to complain, we don't know. Now, Zarda is no longer alive. He died in a wingsuit accident in Switzerland in 2014. But his case was allowed to go on for the very important reason that he was fired solely because he was a homosexual, which is interesting because in New York, the New York State Constitution does protect gender orientation. So I'm not sure how that happened, but it did, and he made it into a federal case, and post-death, he won his federal case. The third case that is in this lesbian, gay, bisexual, transgender decision is a case from Georgia. And the Federal Appeals Court in Atlanta ruled against Gerald Bostock, a gay employee of Clayton County in the Atlanta suburbs. Bostock claimed he was fired in 2013 because he's gay. The county argued that Bostock was let go because of the results of an audit of funds he managed. So here it was not so clear cut that the gentleman was fired because of a sexual orientation. The city actually said they had another reason for firing him and were able to document, at least to some extent, what that was. And the 11th U.S. Circuit Court of Appeals dismissed Bostock's claim in a 3-page opinion that noted the court was bound by a 1979 decision that held discharge for homosexuality is not prohibited by Title VII. So in other words, they didn't decide whether or not he was fired due to a sexual orientation. They just decided that that wasn't a claim that could be made under Title VII. So that went to the Supreme Court, and so now he's allowed to make that claim, but we don't know if he will succeed on that claim. It is still yet to be determined whether he was fired because of his sexual orientation or whether he was fired because of something they found in an audit. But he now can go ahead with his Title VII claim. So it makes a difference. So in his case, that gets to be litigated some more. In the one case, it's moot because the gentleman died. And in the other case, I suppose if Amy wants her job back at the funeral home, if it still exists, they probably would have to rehire her. Unfortunately, in many of these cases where someone is fired, or we presume that they're fired for an illegal reason, the company often can find other reasons to fire someone because no one's perfect. So they just start really documenting every little thing that goes wrong. They were 2 minutes late. Somebody called and complained about them, whatever. Things that happen often with people. I mean, there's traffic. Sometimes people are just grumpy and they call in and complain because that's what they do. And with good employees, normally that doesn't matter. But since this happens with almost everyone, depending on your field, it can be a reason, and they can show it as a reason, look, this is why we let this person go. And unfortunately, in New York State, when you go to the Human Rights Division, they don't allow you to look at other cases and compare it to, how many other employees had the same amount of complaints or whatever. They just make you just stick to the evidence of the one case. And you have to go to them. And so I think that would be a good thing to change, because the court system is prepared to deal with these things and does allow you in the rules of evidence to look at how they're treating other people, whereas the Equal Opportunity Employment Commission doesn't seem to do a whole lot for people who I believe have been truly discriminated against. But hey, that's just my opinion. So again, the Supreme Court didn't say that the originators of the law of Title VII of the Civil Rights Act of 1964, they're not saying that they meant to include gay, lesbian, transgender, and bisexual identity in the law. There's a general acknowledgement that they didn't, but yet they went ahead and they made this ruling anyway. And the show's over, we're done, so we'll see you next week on Law Talk.
Join us every Tuesday at 9 a.m. for Law Talk here on The Patriot, 1230, 1460